This is the Behind the Line podcast, coming to you from the wacky left coast capital of Seattle. News from the Pacific Northwest, the left coast, the U.S., and the world that matters. The stories the MSM won't talk about. Deciphering the truth through all the lies. For more, visit BehindTheLinePodcast.com.
It's Tuesday, January 30th, and here is your daily dose of the Washington State Legislature and some of the wonderful new bills that are being heard to enhance your life here in the great Pacific Northwest. Well, let's get right into it. Senate Bill 6063, SB 6063, regarding the juvenile persistent offender. And we've all probably been watching the news and seen the huge increase of juveniles committing crimes. I know I am personally familiar with this. There are a lot of juveniles committing crimes because juveniles are treated so lightly in this state. And these criminal gangs and organizations know it. So who would they have go out and commit these crimes? Juveniles. Stealing cars, robbing stores, shooting people. You know, those good kids who were always so bright and shiny when they were younger. That's what their parents tell us. So this bill would require a resentencing hearing if a conviction for an offense that occurred when the offender was under the age of 18 was used as a basis for finding the offender was a persistent offender. And this sort of boils down to the three strikes law. They're trying to keep these kids from getting 3 strikes and sentenced to life in prison. The prosecuting attorney for the county where the offender was sentenced as a persistent offender must review each sentencing document and shall make a motion for relief to the original sentencing court if a conviction for an offense that occurred when the offender was under the age of 18 was used as a basis for finding an offender was a persistent offender. So, in essence, juveniles can just commit crime after crime, the same crimes, felony crimes, violent crimes, and it won't be held against them. They'll move into adulthood and basically get to reoffend a whole bunch more times before anything happens. The offender may also make a motion for relief from sentence to the original sentencing court. The sentencing court must grant the motion if it finds conviction for an offense committed when the offender was under the age of 18 was used as a basis for finding that the offender was a persistent offender and must immediately set an expedited date for resentencing. At resentencing, the court must sentence the offender as if the conviction for an offense occurred under the age of 18 was not a most serious offense at the time the original sentence was imposed. Notwithstanding the requirement that any sentence imposed be determined based on the law in effect when the current offense was committed for purposes of resentencing, an offense occurring when the offender was under the age of 18 shall not be considered a most serious offense, regardless whether the offense was committed before, on, or after the effective date of the 2019 law that removed robbery in the second degree from qualifying as a strike offense, because that is a common offense from these wonderful children. The definition of persistent offender is modified to require the offender to be 18 years of age or older on the offense date for prior convictions for most serious offenses to qualify as strike offenses for purposes of the 3 strikes law and 2 strikes law. Why are we allowing juveniles to commit repeated crimes and not be held accountable? I mean, a 13-year-old is old enough to know that they want to change their sex. Is a 16, 17-year-old not old enough to know that what they're doing when they commit crimes is illegal? Are they not capable of understanding the seriousness of it? The staff summary, public testimony, courts have already determined that holding young people in prison for life without parole is cruel and unusual punishment. How about what they did to their victims? Do you care about that? Does that play into your thought process at all? No, it doesn't. These politicians don't care about you, don't care about victims of crime in the state at all. This bill will square the treatment of yesterday's youth with modern laws and hearts. It's all about feelings. Too many youth from older generations were thrown away and given up on before they had a chance. A chance. You had a chance. You got caught twice before you got the third strike, so you had chances. You knew what was coming. We need to give them more chances to hurt people. Decades later, the three strikes law has not increased public safety and has driven racial inequality and mass incarceration. Yes, the race-baiting card. And yes, it has increased public safety because those people are not on the streets, and God knows what they would have done had they been. So yes, in fact, it increased public safety. And I'm sure it affected some people knowing that they could face life in prison and altered their decision to commit a crime. We will just never know who those people are because they didn't commit the crime. So that is one of the stupidest public testimonies I've ever heard. This is one of the stupidest bills. Add them to the list. These politicians are insane. They don't care about anybody's safety except the criminals, except these criminal children who know exactly what they're doing. The sponsors of this wonderful bill, Senators Frame, Peterson, Dhingra, Hasagawa, Cooterer, Wen, Saldana, Wellman, and Wilson. C. Wilson, that is. When will we say enough is enough of this allowing criminals to just run wild in this state? Please sign in to the Washington Legislature website, search this bill, and leave a comment. At least leave a con position. It takes less than 5 minutes to write a quick response to this, but they need to hear it. This is ridiculous. HB 1964 grants the Department of Licensing, DOL, broad authority to enforce fuel tax requirements. Requires the DOL to establish a prorate and fuel tax discovery team to detect and investigate fuel tax and proportional registration violations with authority to seek search warrants, issue subpoenas, perform inspections, and investigate and assess alleged civil violations. Makes a person other than a licensee who is engaged in the business of selling, purchasing, distributing, storing, transporting, or delivering fuel, and who fails to submit required tax reports to the DOL subject to civil and criminal penalties. Requires a fuel licensee who has a fuel license revoked to submit an application for reinstatement and to resolve all outstanding violations, noncompliance items, and debts owed prior to issuance of a new license. Exempts fuel tax reports submitted to the DOL from public inspection and copying, subject to certain specified exceptions. This, as it states, gives broad authority to the DOL. A bunch of idiots already who are incapable of doing their job efficiently and effectively. Now you're going to let them have an enforcement team issuing search warrants and subpoenas. We don't need state agencies to have these authorities over us. I'm sorry. I know that they're thirsty for their fuel tax, obviously. This is a 8-page bill, which is pretty long for these bills. The fact that it's exempt from public inspection, so We can't know what they're doing. They get to go out and do this stuff without any sort of public disclosure. They're estimating that they'll collect $16 million per biennium with the changes made in this bill. Of course, this isn't going to affect you at the gas pumps. This is going to be semi-truck drivers mainly, and people transporting fuel from distributors. At any rate, you open the door for DOL to have this sort of broad authority and to be able to make these kind of enforcement actions, I think is wrong. Because eventually they're going to find a reason to have an enforcement team for Joe Citizen. Who knows what or why, but they'll come up with something because they need money. They always need more money. Should people pay their taxes? Yeah, I suppose they should, yeah. But do we need to grant another state agency this sort of authority to go out and issue subpoenas and search warrants and do God knows what, and there's no public disclosure? You can't go look up and see what they did because it's a secret. No, I don't agree. I don't think this should pass. They're getting enough money from us as it is. HB 2126. This is about tiny homes. So we've already talked about how the state wants to, or has actually, allowed multi-unit dwellings to be built on what was historically single-family residential, and the amount and number of dwellings depends on the size of the cities, because they would like to eliminate single-family dwellings. They don't want you to have a house to yourself with a yard. They want you in a box with everybody else and some sort of small area outside if you're lucky. Counties planning under the GMA may authorize development of detached accessory dwelling units, a tiny home, in rural areas on lots of any size, even where otherwise prohibited by a comprehensive plan, countywide planning policy, or multi-county planning policy if the DADUs are subject, the tiny homes, are subject to the following developmental regulations. So, doesn't matter if your city or county has decided that they want to preserve space or not have low-income dwellings all scattered throughout your neighborhood. The state is going to override that. Doesn't matter what you as a majority would like to have where you live. A parcel may not have more than one accessory dwelling unit, whether attached or detached. The tiny home must be subject, the DADU, I'm going to call them tiny homes, must be subject to certain water supply requirements and may not be located on a parcel that uses a water source that is closed to further appropriation, must use water that is part of the water right for the primary dwelling, and withdrawals of water must be metered. The tiny home may not be located within or encroach upon existing critical area buffers. The building permit applicant must demonstrate that the sewage, septic, or on-site sewage system can handle the additional demand from the tiny home. If the tiny home will be connected to an existing system, the system must be inspected by a licensed contractor prior to issuance of the building permit. The floor area of the tiny home may not exceed the lesser of 1,296 square feet. That's a tiny home, huh? That's bigger than most people's apartments. Or the square footage that could be authorized by the county as an expansion of the primary dwelling to create an attached ADU. The tiny home must be constructed so that the exterior material, roof form, window spacing, and proportions approximate those of the primary dwelling, unless the tiny home is a manufactured mobile home. Not so tiny anymore, are they? So you could have a single wide slammed behind a residential house in the backyard in your neighborhood. Isn't that awesome? The tiny home must use the same driveway as the primary dwelling. The tiny home must be sited to prevent loss of agricultural land or forest land. A parcel may not be subdivided for the purposes of avoiding these development regulations. The comprehensive plan, countywide planning policy, or multi-county planning policy for any county that authorizes development of tiny homes under the specified development regulations must be amended at its next regularly scheduled update to allow development of tiny homes consistent with the specified development regulations. That's right. The state will decide how your county is going to proceed in regards to housing. Not the county, not the people who live in the county, but the state. You know, those people from Seattle mostly deciding for you. Population growth from the development of tiny homes that comply with the specified development regulations may not be counted for the purpose of determining whether a county is achieving rural or urban growth targets contained in a comprehensive plan, countywide planning policy, or multi-county planning policy. So anybody that lives in a tiny home, they don't count towards population increase. Nope. Because they don't want to see those numbers of people packed in everywhere. The section in the GMA that requires cities and counties to protect agricultural lands of long-term commercial significance may not be interpreted to limit the development of tiny homes that comply with the specified development regulations. So apparently we're not that worried about protecting agricultural land, right? All they care about is packing as many people in as possible everywhere. This is going to turn us into a third world country, state, right here. Good old Washington. We're going to pack these people in everywhere, in these crappy little houses everywhere. And we're going to overload all these neighborhoods. And we're not going to count the people. Just more insanity from our politicians, who, of course, live in their big homes with fenced properties. They won't be building any tiny homes there, guaranteed. Your neighborhood, though, yeah, that's fine. Let's put some low-income tiny homes into these neighborhoods. Let's take away people's dream of owning a home with a yard with space for their children to play in. I have no words, honestly, for all these laws that are attacking property owners. Here's another anti-law enforcement bill. This would be HB 1445, which will authorize the Attorney General to investigate and bring an action against a law enforcement agency of any county, city, town, or political subdivision of the state, or against a local corrections agency for any county, city, or local agency for violation of state constitution or state law. Specifically, the Attorney General may investigate violations of the state constitution and state law on its own initiative or in response to investigations or reports from independent oversight bodies, issue written civil investigation demands for documents, oral testimony, and answers to written interrogatories, and institute civil actions in the courts for injunctive or declaratory relief, damages, costs, and reasonable attorney's fees. Conferral requirements. Before beginning any formal investigative steps, the Attorney General must confer with the U.S. Department of Justice to ensure law enforcement resources are being used efficiently and there are no conflicts with any independent investigations by the DOJ. If a local agency is subject to a DOJ investigation, the Attorney General is prohibited from seeking relief or remedies in conflict with federal action. If an investigation is initiated, the Attorney General must confer with the Office of Independent Investigations, another state agency that investigates law enforcement, to ensure that any investigation under this section will not interfere with or impede an ongoing investigation being conducted by them. because we're going to have all these agencies investigating the cops. Meanwhile, we're cutting the sentencing and punishment for criminals. Why are we so worried about punishing cops when we're turning these criminals loose all over the place? Insane. By July 1st, 2024, the Attorney General, Sideshow Bob, must develop and publish model policies for law enforcement. He's going to develop and publish model policies for law enforcement and local correction agencies. Accountability systems specifying model practices for receiving complaints of serious misconduct, conducting investigations, imposing discipline, and addressing disciplinary appeals. When developing model policies, the Attorney General must consult with the Criminal Justice Training Commission, also a liberal state organization now that I would not trust, whom they are trying to give the authority to revoke any law enforcement officer certification and or sheriff, elected sheriff, so they can put their own sheriff in power if they don't like what the sheriff is doing. The Office of Independent Investigations, law enforcement and local correction agencies, police and local corrections unions, independent oversight bodies, city attorneys, county prosecutors, people impacted by police or local corrections misconduct, experts in police and jail accountability advocates. You're going to get all these people together to come up with your policy, Sideshow Bob. Sideshow Bob, who was some lackey attorney before he came this crap politician, who has never been an officer, knows nothing about being a cop, like most of these people who try to create all these rules and enforce all this garbage. Meanwhile, he is allowing criminals to be turned loose, commit crimes, commit violent actions, and not be held accountable. We don't need more state oversight, especially from this guy, especially from the Attorney General's office. What we need is more law enforcement and criminal justice. We need more justice for the victims in this state, who the Democrats just ignore because they're more concerned about social justice and giving people chance after chance after chance after chance to continue to commit crimes and hurt you. Also, while trying to disarm the rest of us to keep us from protecting ourselves against these freaks that they turn loose on the street. This bill is a hard no for me. The Attorney General's office does not need any more authority in this state. Folks, it's up to us to make changes in this state, and contrary to what you think, your voice does matter when it comes to these bills. If they get enough people against them, it does make a difference. So just take a minute. Google Washington State Legislature. It should be the first website that comes up. Otherwise, go to leg.wa.gov. It'll bring you to the home page. You can just click on the House floor calendar or the Senate floor calendar link, and it'll list every law, every bill being heard that day. And you can just look through the list real quick and see the ones that fancy your attention and click on it. And then you can just click to leave a comment or even just a position, pro or con, or a short comment, 5,000 words or less. It only takes a minute of your time. Please, we've got to put a stop to these ridiculous, crazy bills that are coming out, because unless they hear from us, they're just going to keep doing it. Because the people who don't have jobs and aren't busy, and I know most of us are, and we don't want to take the time to do this, but these people that are pushing this crap on us don't work, don't have jobs, and they spend their time doing this stuff, and that's why this is going through. We've got to put a stop to it.
for listening to the Behind the Line podcast. If you like this broadcast, please like and share it. Please follow us on Facebook, Rumble, YouTube, Twitter, Truth Social, Telegram, Gab, Parler, and LinkedIn. You can find our podcast at BehindTheLinePodcast.com, NetNewsNetwork.net, and on Anchor, Spotify, Amazon Podcasts, Apple Podcasts, Google Podcasts, iHeartRadio, TuneIn, and anywhere podcasts can be found. Thank you for your support.